Do you own rental properties in California and think your living trust protects you from lawsuits? Think again. A single tenant injury could still lead to lawsuits that name you personally, putting your home, your retirement accounts, and everything else you've worked for at risk. In the next few minutes, I will do my best to explain how using LLCs for each property can at least isolate liability without you giving up the probate avoidance benefit of your living trust. But a word of caution, LLCs aren't a magic shield, especially in California. Single-member LLCs have weaker protections and poor management can still pierce that protection. So let's break down what actually works and what doesn't. Hi, I'm Ali Talai, a trust and asset protection attorney and founder of Talai Law Offices. I recently started making videos on YouTube with the goal of providing educational content that helps individuals and families make smarter decisions about estate planning, asset protection, and preserving generational wealth. I'm passionate about helping clients create estate plans that protect their legacy, not just distribute their assets. Estate planning is full of legal nuances that can impact both your family and your future finances. And that is why I like to invite you to join my free webinar, Avoiding the 5 Biggest Estate Planning Mistakes. In order to sign up for the webinar, you can go to Talai Law, click on the events page, or use the link in the description below. All right, so let's start by clearing up a common misconception. What does a living trust actually do? A living trust is like a legal container for your assets. During your lifetime, you're in complete control. You are the trustee, which means you can have legally the authority to manage the trust, and that means that maybe you need to get a loan, maybe you're going to get a home equity line of credit, maybe you decide to rent the property, enter into a rental agreement, lease agreement, complete a 1031 exchange. You can do whatever you want to do. Whatever you could have done before, you still can do. And the good part is that you can still actually use the assets of the trust. But when you unfortunately pass away, your successor trustee takes over and distributes the assets according to your instructions without the need of the probate process or the probate court. Sounds great so far, right? But here's the catch. The word revocable is key because you can undo the trust and take the assets back at any time. The law treats those assets as still legally yours, and that's where the asset protection limits come in. This is where many people get misled. Some believe that putting property into a living trust protects it from lawsuits. Unfortunately, that is simply not true. Living trusts are not asset protection tools. They don't shield your property from lawsuits, creditors, or legal judgments. In fact, they provide virtually no protection at all during your lifetime. You can use them to create asset protection trusts for the inheritance that you're going to leave to your kids. And that is because at the time you pass away, your revocable living trust will become an irrevocable trust. However, while you're alive, your revocable living trust cannot provide any asset protection for you. California Probate Code Section 18200 makes it clear the assets in a revocable trust remains subject to the claims of the settlor's creditors to the extent the settlor retains the power to revoke the trust. The settlor is the person who creates the trust, and again, in a revocable living trust, you're the one who created the trust, and since you have the power to revoke it, the law is clear that a trust like that cannot provide you any asset protection. All right, so let's say you own a duplex in California and it's titled in your revocable trust. Your tenant slips on a wet walkway, gets injured, and sues. You may be asking who will be liable, and the answer to that is you will be liable. And the reason is that the lawsuit isn't against the trust because you control the trust and the assets that are in there. You're on the hook personally. The trust doesn't create any legal wall between you and the liability. California courts have been consistent in indicating that a revocable trust offers no protection from lawsuits or creditors while the settlor is alive. So you might be asking, what is the solution? If you own rental properties, consider placing each one into a properly maintained LLC while keeping your trust as the owner and member of the LLC. This approach maintains your probate planning while adding a layer of asset protection and liability protection. But remember, not all LLCs are created equal. In California, single-member LLCs get limited protection and poor compliance can pierce the entity. The key is proper formation, operation, and separation of assets. All right, so let's talk about what you're actually exposed to as a rental property owner. Every time you have somebody that walks into your property, you can potentially face liabilities, slip and fall accidents, fires, carbon monoxide poisoning, lead paint exposure, discrimination claims. Should I go on or should I stop here? California's tenant protection laws have become increasingly strict, and damage awards in personal injury cases continue to climb. I've seen clients face six-figure lawsuits over relatively minor incidents. One case involved a tenant who claimed carbon monoxide exposure from a faulty water heater. Even though the landlord had followed all the maintenance requirements, the legal fee just to defend against the lawsuit exceeded $80,000. And that was before any settlement. What makes this particularly dangerous is that your rental property liability doesn't stop at the property itself. If you're personally liable, a plaintiff can go after your personal residence, your retirement accounts, your other investment account, essentially everything you own. Your living trust provides no firewall against this type of liability. California's fair rental housing laws under the Unruh Civil Rights Act creates additional exposures. Discrimination claims, whether valid or not, can result in significant legal costs and potential damages. These lawsuits target you personally as the property owner, and it doesn't matter if you own the property under your personal name or under your LLC. So what should you do if a living trust doesn't protect your assets? The answer lies in creating legal separations between you and your rental properties, primarily through the use of limited liability company. In asset protections, I have mentioned this many times in different videos that I have done before, is that there's nothing that anybody can do that would 100% protect the assets. What we can do is we can create barriers between the potential creditors and our assets, and more barriers we have, the harder it becomes for the creditor to actually attach our real estate or our asset. It provides us a greater chance to be able to protect our asset. What we want to do is we want to make it more difficult, and that we can definitely do. When set up and maintained correctly, an LLC creates a liability firewall. So if someone is injured on the property or files a lawsuit, they're generally limited to suing the LLC and going after only the assets owned by the LLC. Your personal home, your savings, and your other investments are not directly exposed. But here's the California-specific reality. A single-member LLC, as I mentioned earlier, doesn't offer a whole lot of asset protection. Courts here are more willing to allow creditors to break through the LLC structure, especially if it was poorly maintained or if it looks like you're treating it as a personal piggy bank. So simply forming an LLC isn't enough. All right, so how do we strengthen protection in California? If you are in California, here are a few ways you can make your LLC structure more effective. Number one, you could use a Wyoming holding LLC. You can set up a Wyoming holding LLC as the holding company, then have the Wyoming entity own the California LLC. Wyoming offers stronger protections for single-member LLC, including better charging order protection and more robust asset protection statutes. The other solution could be that you create a multi-member LLC. In some cases, you could actually add a legitimate second member. A lot of times we will create a specific trust for the children and have that trust be named as a second member. That can increase your protection under California law, though it requires proper structuring and documentation. Next is that you can keep each property in a separate LLC. Don't dump all your rental properties into one entity. Instead, isolate liability by forming a separate LLC for each property. That way, a lawsuit against one property doesn't expose the other properties. And lastly, maintain corporate formalities, regardless of where your LLC is formed. Always treat it like a separate legal entity. That means make sure it has separate bank accounts. Make sure it has its own operating agreement. Make sure the operating agreement is actually written and it's not a verbal operating agreement. Make sure you have proper bookkeeping. And also make sure you don't commingle personal and business funds. And one more thing, if you are going to sign a lease agreement or a contract agreement, don't sign it under your own personal name. Make sure you sign it under the LLC's name. That is another really important factor. In short, LLCs can provide meaningful asset protection, but in California, it takes careful planning to make them work the way people expect. When structured correctly, often with a Wyoming holding company, and create separation between your entities and your personal assets, LLCs become a powerful layer of protection that your living trust alone simply cannot offer. Now, I'm not saying living trusts are bad. They're essential for estate planning. The solution isn't to abandon your trust. It's to use both tools strategically. You can have your LLC membership interest owned by your living trust. This gives you the liability protection that the LLC can provide, and also the protection that you could get from your living trust to avoid probate when you're not here, so your kids don't have to go to probate court, have to pay a lot of expenses and legal fees and wait a year or 2 years so that they can finally get their inheritance. The cost of setting up proper protection is minimal compared to the potential exposure you face every day your rental properties remain in your living trust. Don't let a misunderstanding about revocable living trust put your family's financial future at risk. Now, getting your LLC structure set up correctly is crucial. But here is another piece to this puzzle that many investors unfortunately get wrong or they overlook. And it could cost you everything, even with perfect entity structure in place. In my next video, I'm going to walk you through the 3 most dangerous mistakes California rental property owner make that destroys their asset protection, even when they have LLC set up correctly. These aren't obscure legal technicalities. They are common practices that I see successful investors do every day without realizing they're opening themselves to massive lawsuits and personal liability. If you own rental properties in California, this next video could literally save you from losing everything you worked for. Make sure you watch it as soon as it goes live, because every day you wait is another day you're potentially exposed. I look forward to seeing you over there.